Good afternoon, everyone. We'll just wait 1 more minute for additional people to join before we start the session. Okay, let us start. Speaking on behalf of OGH Legal, it's our pleasure to host this webinar on what we hope is a very interesting topic. Today's webinar will be moderated by Nicholas Cowie, and we have Rana Shashaa of Deloitte and OGH own Mohamed ElGhatit. Let me quickly introduce our speakers today. Rana Shashaa is a partner in the forensic Middle East practice with over 14 years of experience within the firm. She works on high-profile investigations and litigation matters across the Middle East region and Europe. Rana also acts as an expert witness before the courts in the UAE and is a certified fraud examiner. Nicholas Cowie is the regional legal counsel for WSP in the Middle East. He is responsible for managing a variety of legal issues impacting WSP in the Middle East, including on corporate, contractual, and dispute resolution matters. Prior to this, Nicholas acted as senior legal counsel for a major property development and construction group based in Dubai. Mohamed ElGhatit is a founding partner of OGH. Mohamed has more than 18 years experience in trying cases in the UAE courts and the wider region. He previously was the director of the DIFC LCIA Arbitration Center, and prior to that, he was leader of Hogan Lovells disputes practice in the UAE. He is recognized by Chambers and Legal 500 for his local law and local court litigation expertise. We hope you find the webinar interesting, and please feed in your questions on the platform, and we will try to get to as much as we can at the end of the discussion. Nicholas, over to you.
Thank you very much. So just to reinforce that point, if at any time during this presentation any questions occur to you, please do type your messages into the chat. You can send that to me directly, and we'll get through as many of those as we can during the Q&A session at the end of this presentation. Right, before we get to the Q&A session, I have a couple of introductory questions I'd like to go through. My first is for Mohamed. I'd like you to give me a quick primer, if you could, on the court expert procedure. And in particular, I'd like you to run me through any differences that may arise in the various regimes in the Emirates.
Thank you, Nicholas, and thank you both, you and Rana, for attending today. I think in introducing Rana, the name of her firm, Deloitte, was missed out, and probably that's OGH's fault. So we definitely welcome you both, and thank you both for your involvement in today's discussion. Nicholas, to your question, I think those of the audience, and obviously you, having spent some time in the region, will know that the regime of expert determination in UAE courts is quite part and parcel of litigating in the UAE. Pursuant to the law, a judge has the authority to mandate a certain part of a case to an expert. The purpose being that that part is of technical nature, being accounting, engineering, construction, nature, which require that expert and that expertise to opine on specific technical issues and report back to the court. So it's investigation and reporting. That's the role of the expert. And the manner in which the expert takes on that role pursuant to the law is by that role being mandated by the judge. Now, there are certain quirks in different emirates in respect of that mandate. For example, in Dubai, you can go directly to a court-appointed expert seeking a finding on one of those technical issues. One example is the Dubai Center for Amicable Settlement of Disputes. The center is part of the Dubai judiciary. It's part of the Dubai courts, but instead of going to a judge and seeking an appointment of an expert, or the judge doing that on his own prerogative, a party can directly go to the Center of Amicable Settlement of Disputes and seek the immediate and automatic appointment of an expert to determine a specific technical issues. For other emirates, you still have to go to court. So I would say that Dubai has that advantage, potentially both in time and predictability of getting that side but immediate avenue to secure expert determination on issues of technical nature. I hope that addresses your question, but obviously if you want me to emphasize on anything particularly, I'm happy to do so.
That certainly addresses my question. I do have one follow-up question on that. You mentioned the Center for the Amicable Resolution of Disputes. My understanding is that this isn't, the decision of this expert wouldn't necessarily be binding upon the court later, but would be considered persuasive. Is that the case?
That's correct. That's correct. And I think you touched on probably a very important point, which is what does the expert actually produce? Does he produce a decision or a finding, or does he produce a report, which is, as you said, subject to review or consideration by a judge? And many times parties, either claimants who procured a favorable expert determination, or a respondent who are on the side or on the receiving side of a negative expert determination, either are very optimistic or pessimistic because they fear, well, an expert has determined against me, or the other way around. And the answer is, as you put it, the report is simply a finding, but it is not a final determination, but rather should only be considered by the judge as an investigation and the result of it on a technical matter. It might influence the judge's decision, but it should not be the determinative factor in the judge's decision.
Very good, thank you. That's certainly accorded with my own experiences, where if we've been quite confident in the strength of our case, we have gone for this non-binding initial expert, essentially to express to the other side the strength of our case with a view then to an early settlement.
Precisely.
Okay, Rana, my next question is for you. I would like you to run through, from your perspective as an expert, what you consider to be the role of the expert, and whether you see any differences in theory and in practice.
First of all, good afternoon, everyone, and thank you, OGH, for inviting me to take part of this important webinar. It is important to note that there are two types of experts which would appear before the Dubai courts. Firstly, there is a list of registered experts with the Dubai courts. These are primarily individuals with an accounting background who can assign any matter from the active cases. I mean, accounting or engineering, like what Mohamed says, or mechanical, any type of expertise that is registered, or real estate experts registered in the court appointed expert list. And then alternatively, there are firms such as Deloitte who are not on the list of registered experts, but who are appointed on a case-by-case basis, usually at the request and agreement of both parties, or appointed directly by the Amicable Settlement Department of the Dubai courts. In these instances, a partner from the appointed firm, such as Deloitte, will serve as an expert and will need to give oath on a case-by-case basis. The reason why large firms do not appear on the list of registered experts is due to the fact that the registered experts are obliged to handle any case that is assigned to them, regardless of the size of the case. So we may end up having really small cases that it does not suit our profile or the aim of the firm, which cases we would like to be part of. So given the volume of cases before the Dubai courts, it is common for very small disputes and matters, such as tenants, landlord dispute of small commercial properties, to be assigned to the registered experts. So therefore, it would be impractical for the large firms to be appointed on such matters, as the individuals from the registered expert list would be more appropriate for those for those cases to be assigned to them. Regardless of the method of their appointment, the expert has one overarching role, in my opinion, to fulfill the mandate assigned to them with a means to assist the court in rendering fair judgment. Experts must remain unbiased, in my opinion. So regardless of which party has initially introduced them to the case, so as to ensure that proper justice is provided. They need to maintain their independence as much as they can. Of course, disputes always is an art and it's not a science. There are ways of presenting stuff in the right way and flashing things out, that's fine, but try not to be really biased in the approach that you present certain arguments, because that will not really I wouldn't say it will really be presented well in front of the judge, and the judge would know, that you're being biased just because you're acting on behalf of your clients. The third type of role that can be adopted is not an official expert role, but rather one as party appointed advisor, whereby one party appoints their own advisor. This party appointed advisor can liaise with the court appointed expert with a view to assisting their clients. And this is a very important role. So, Mohamed can shed light soon about the rule recently on submitting an advisory report. I don't know, Mohamed, if you want to highlight this now. Do you want to?
Yeah, sure. No, just a quick one. The Dubai courts, sorry, the Abu Dhabi courts, now with any new case that is submitted or registered with the courts, the court clerks will not register the case except if the parties supplement their statement of claim with an expert report. Now, obviously, the immediate effect is good business, but I think to some extent there is a benefit to that, because it jumpstarts what will eventually happen, which that experts will be involved. So why not start the case with it?
Yeah,
I can elaborate on that more, but I'm conscious that I don't want to break Rana's
no, it's fine. So I have served as both a court-appointed expert and a party-appointed advisor. Ultimately, the two roles require the same depth of expertise and attention to details. The only difference is that with a party-appointed role, you are naturally only receiving information from one party rather than, sorry. Can you hear me?
Yes, we can.
Yes, we can.
My Jabra has gone. So information from one party rather than both. So this is not to suggest that the party-appointed advisor should be unfair or biased to their clients, as I said. In fact, on many occasions, the role as a party-appointed advisor, I have had to convince the client that the proposed position has many errors and will hurt them in the long run. So they may want to hear it, but they may not want to hear it, but it's better that they hear it from me rather than the judge. So it is important that we really think through those calculations and present something that is reasonable and reliable. And this is really important in my opinion. And working aside the accounting expert appointed by the court is also vetted to any case, because those usually court-appointed experts are hired in a low-fee basis, and therefore they are unable to do many analyses that we can assist them with, and with bringing that international experience into the table and the way how they look into the account, the methodology of the calculation, or from a construction perspective, the delay analysis, and so on and so forth. It is important to have that international experience, but also have the capability from a budget perspective to look at those and question certain approaches and have different scenarios and you know, just rationalize the claims that you are quantifying as much as you can. And so the communication really is, and I'm going to cover that in the next question, is vital in any court case, to be honest, whether between the court-appointed expert and the advisor, or between the expert and the advisor with the legal with the lawyers on the case. I hope that is helpful for everyone.
That was extremely helpful, Rana. Thank you very much. Now, this next question is of great importance to me. I've managed several hundred litigations in the region, and I think easily 99% of those have been referred to an expert. Even criminal prosecutions I've been involved in have been referred to an expert. So as in-house counsel, it's of utmost importance to me to manage the expert process well. So this next question is to both of you. I'll refer to Mohamed first. What are some practical tips for parties and their in-house counsel to prepare a case to run it effectively and efficiently through the expert procedure?
Thank you, Nicholas. I think a lot of the people listening in, particularly if they're working on your side of the table, sort of working for internal clients, I hope will find that question important. I think hopefully we can assist with an answer that is useful or practically useful. My experience suggests that it is always, as you said, probable, highly probable, that the matter will end up with an expert. Talking here about, as you said, even matters that do not justify an expert because of their nature, but also in respect of matters that do not justify an expert because of the party's position. So even where a claim is not defended, sometimes the court will still refer the matter to an expert, which I find obviously peculiar, and I'm sure you from the in-house counsel side might even say it's frustrating, reasonably so, but it's the reality. And I think with that reality, it would be naive not to prepare for that, as I said, probable eventuality. And I think key is to get someone on board in the beginning. Now, that could mean someone like Rana, who is an expert by default in whatever sector she is an expert in. For Rana, it's forensic accounting and forensic review, but also in respect of knowing the language of the experts. And I mean here language not in terms of the explicit language being Arabic, but also, and probably more important, in addition to the language in the normal sense, which is Arabic, but also the language of the technical language, the expected material from the expert, because a court-appointed expert will expect things that are very different than what you would expect, for example, in an arbitration, where potentially experts appointed by the tribunal or even party-appointed experts will deal with things very differently than a court-appointed expert. So it's important to know what the expert will want. It's important to prepare that documentation, because it's not necessarily what you believe is going to support your case or what you believe will evidence your claim, but rather what is important or what the expert will be considering as important. I think a lot of times these are not the same thing. Again, it might sound illogical, but it's the reality. So I think going back to your question, the first tip is be prepared with someone on board from day one. Now, the quantum in dispute might dictate whether that is someone who is specialized, like Rana, a Big Four type outfit like Deloitte, or someone of a middle size or a smaller size, etc. So the choice or the selection will depend on the commercial justification, and it might very well be the local counsel. So sometimes on smaller mandates, I will suggest to the client that we can, from our experience, have that general sense of what the expert wants at this early stage, and we can defer or delay when we get our own consultant on board to a later stage. Another important thing is documents. Documents. And I remember when I was still starting practice in private practice back in 2002, my mentor was always saying originals. Now things have moved on, but still, notwithstanding, there is that attractiveness of original stamped documents. They just carry that additional weight. So even before a dispute happens, have your documentation in place. And we're not talking about only scanned documents, but originals, as I said. The next tip is to understand, once an expert is appointed, understand what he wants. Don't dictate what you have. And I think it's crucial to do that, and it's crucial to listen to the expert. It's crucial to be prepared, of course, but it's crucial to be lean enough and flexible enough to be able to adjust and adapt and get him what he wants. And this is a perfect segue for my last tip. There might be other tips, but obviously conscious of time, I'll stop at 3. A tip that links to something that Rana mentioned before, which is, in essence, don't treat the expert as an adversary. The expert is someone that you want to persuade, and if you want to be critical of a finding or an initial finding that he's made or an approach that he's taking, try to persuade him as opposed to try to prove him wrong. With that, I would just give you a war story, a very recent one. We're involved in a case that involves a multi-party litigation, and there are certain questions of fact that we felt are going to be difficult for the expert to disregard. I shouldn't say a question of fact, I would say findings of fact. and we actually built our strategy on the basis, on our legal strategy, I should add, on the basis that it will be difficult to dissuade the expert from accepting these facts. Others in the dispute tried to focus on disproving those facts, and they end up losing because they wanted to break that issue. We simply took it as a given and tried to adjust our legal strategy to adapt. And thankfully, alhamdulillah, we were the successful party because we dealt with that practicality, that realization that we're not before an arbitration, we're not before an English court type of forum. This is a unique forum. You have to be knowledgeable of how it works, as opposed to simply run it as you would any other dispute in any other forum, international or private.
Fantastic. That's very helpful. I agree with all those points. I've taken some useful notes to share with my team back at WSP. Thank you very much. I may even pay it. Rana, same question for you from the point of view of an expert. Can you give some practical tips to companies and their counsel for how best to approach the expert process?
Sure. So from a practical perspective, I would offer the following advice to anyone considering raising a case in the Dubai courts that will involve the appointment of an expert or a party-appointed advisor. First, know the expert's role. It is important to be aware that the expert's role is to primarily quantify the financial impact, the damages relating to the case, whether it is engineering or accounting or investigation, or it is at the end there is a quantification of losses that needs to be presented. So as well as any other related matters to the quantification, such as commentary on the evidence available or insights into accounting policies and practices. This is really you've got to know the expert role. That's very important for you for the in-house legal counsel or the external legal counsel to understand that this is basically what the expert should focus on. The expert will be required to have an understanding of the underlying legal arguments, and this is very important, but would not provide any opinions on law. So I have seen many experts where they really go into the report and provide legal opinions, and it doesn't come across really right, okay? Because we're not experts in law. We are experts in our own fields. So it is important not to do that in any of the reports. It's just to focus on your expertise. It's important to understand the legal argument, because this is where you're going to build your quantification of losses, but not to comment on something that is outside your expertise. Second is communication with the expert. It is important to recognize that the expert's role is not just with numbers. I mean, Mohamed has highlighted this, but I want to reiterate, communication is key. So of equal and maybe even more important is the ability of the expert to present their approach and methodology in a clear and concise manner, so that non-accountants, particularly the judge, can immediately grasp the fundamentals of the quantification. And I've always learned that you have to write the report in a way that a 10-year-old boy can understand it. So it's not complicated report, but the approach and the methodology is very clear. How did you arrive into those conclusions? What is your approach? What is your methodology that you have adopted? If there are some scenario analysis that you have also considered, clearly include those in your report with the required background on why did you consider those scenarios. So it could be evaluation method, DCF, or comparable method, or other, or net assets value, or it could be any other scenario analysis that you want to include in your report. But it's important not to assume that the judge understands what does DCF, discounted cash flows, means. Do not use really very technical words without an explanation of what does it mean, because I mean he might have this knowledge, but he may not. So, and it is important that the report is really self-explanatory, because he's going to rely on this report. And that's why where I see most of the experts fail in really presenting the work that they have undertaken in the report. So this is the main benefit that a party-appointed advisor can offer also, because they can speak the same accounting language as the court-appointed expert and assist providing the right information and highlighting the areas for further consideration. He may not understand certain area. We may flourish this to him, or may explain and guide, but it is important that you do that sensitively. It is, at the end of the day, the court-appointed expert, he has a role and he has a duty that he needs to fulfill, and we have to respect it. So the communication is an art with him, really. It's showing that you're not influencing his decision, but rather showing him the facts and how you're looking at the scenario in different perspective, and how, so he may consider your perspective as a useful way of looking at it, and may adopt it. So it is important to stay close to him and provide him with the required information as much as you can. And again, I would like to highlight that your role is not to be biased towards your client only, but also to be fair to the case that is in the front of you, to the both parties, because your reputation is there down the line, and you have to make sure that your reputation is not damaged. So, third, building an effective relationship with legal counsel. Whether you're dealing,
lawyers and their consultants.
Natural enemies.
Yes. Third, building an effective relationship with legal counsel. So whether you're dealing with a court-appointed expert or a party-appointed advisor, the most important element is to build an effective working relationship with the expert or the advisor. In the case of working with an expert, you need to ensure that they are receiving the right information to meet their mandate and reviewing all the matters in a scope in a thorough manner. I saw in many incidents where they basically do not cover certain areas in the scope. Okay, so it is important that you go through that scope and understand it from the beginning, and ensure that whether the advisor or the court-appointed experts really fulfill his duty in total. I mean, he would need to demonstrate this to the judge anyway if he's the court-appointed expert, but it is important to understand that he has fulfilled it rightly, and not only fulfill it by just crossing it from the list.
Absolutely.
In the case of, yeah, exactly. In the case of working with an expert, you need to ensure that they are, I mean, even with the advisor, you need to leverage the value they can offer. So given their experience, they can highlight potential errors in the methodology. So critiquing that expert, I mean, court-appointed expert, and not always critiquing it in a, it's not, critique is not a bad word. I wouldn't say that. Critique it in a good way, like maybe there are errors in the methodology, errors in the quantification. And we have spotted many times errors in many reports. So it is important to leverage and use those advisors to the benefit of the case. So they can even provide sensitivity and I said sensitivity and scenario analysis so that they can you can appreciate the impact of certain assumptions on the quantification. It is important, the key tip here, that the assumptions used in the quantification do make sense. You're not going to use assumptions that is not based on your market. You don't use assumptions. If the damage is in the UAE, you can't just use assumption from the US and say based on the US market is this and this and this. So it is important to really use assumptions that reflect the market that you are in and reasonable assumptions from risk perspective or from other assumptions that we use in the DCF method, for example, projections, or for example, in the construction industry, losses that you have incurred from not taking on other projects at the time when your performance bond is blocked with banks. So do you have really the underlying documentation to prove that? Do you really have the loss of opportunity that to demonstrate this, that you have really lost that opportunity, or the market was down at that time and actually you were better off, that your performance bond was blocked at that time, you didn't take that project and you lost a lot more money. So it is very important. People usually think that the court appoint the expert role, advisor role is easy, and you know, why do they want all of this or time and so on. It is important not to underestimate the work that is required by the expert and lawyers, because they don't really they're not experts in this field, of course, and we appreciate your expertise, because I'm not expert in law as well, but I mean, sometimes they think that they can get things in a day. Okay, can we have this today? I'm like, okay, sure, but I mean, we need to do it. There's a lot of work that needs to be undertaken in order to get you the right quantification of losses that you need to present for your clients. I hope that has given you some practical advice in this important area.
That certainly has, Rana. Thank you very much. And yes, rushing the experts does certainly sound like a thing that lawyers would do. I have been guilty of that myself, not to my advantage.
I think, Nicholas, the fault is in-house lawyers, because you rush us and we rush them.
I see. Well, good to know that we have someone to blame then.
Nicholas, just if I may, it just occurred to me that, and you will know that, that the reason why that preparation for the expert stage in the court, and the reason why where the case makes it appropriate and justifies it, a own private consultant or your own party appointed consultant is important and essential, is because not necessarily the legal impact of the expert report or the outcome of the court expert report, but rather the practical implication of that expert report. And here it's important to note that, and that is more of a practical issue as opposed to a legal one, is that when the court or the judge mandates an expert, and I mentioned in the beginning that he is authorized, the judge is authorized to mandate an expert to review a technical issue, what ends up happening is that the expert goes beyond that and transgresses on issues of party position, contractual liability, breach of contract and whether it occurred or not, nature of relationships. So you end up with an expert report that not only deals with issues of that particular technical point, but then in essence determines the case or determine the party's position in a case. And the risk is that, again, practical versus law, is that judges, not only in the UAE, but across the Arab world, sometimes simply adopt that expert report into their decision without even considering its implication without considering its credibility, because obviously, as I said, they sometimes make determination on issues of law as opposed to only focus on issues of fact or technical issues. So the importance of ensuring that you take the expert determination stage extremely seriously cannot be overemphasized, because it might end up being the case, win or lose. Now, I'm not saying that happens all the time, because many a times you find judges keen on listening to parties' comments on expert determinations, keen on understanding or realizing that the expert has transgressed and issued reports on issues that had nothing to do with the technical issues, and thereby either referring the matter back to an expert for a reconsideration or appointing a new expert. But more times than otherwise, judges adopt it. So it's very important and very critical, and essentially the battle, if there was one in a particular stage in a case. Sorry, I would just want to emphasize that point for people who are.
Oh, it absolutely bears emphasizing. It's something I've had a great deal of difficulty getting my own clients to understand, particularly Western companies who are less familiar with the expert process will treat it as a formality or a nuisance, and they will often assign a very junior person who's unfamiliar with the case and does not have the necessary documents, and then will act shocked when the report goes against them. In fact, we've been getting some excellent Q&A questions. I'm going to raise one now because it's quite relevant. One of them here is that, is it customary for the court to accept the conclusions reached by an expert and not to accept any of the criticisms raised by either party? And if so, what are the options available to the parties in this case?
Should I have a stab, or do you want?
Yeah, if you could have a stab at it, I think.
Well, I think, it's a perfectly timed question, because I think that was ultimately what I was getting to when I was making my interjection. The sad but reality is that the determinations of the experts are probably going to be adopted by the court. Having said that, if you are able to bring in someone like Rana, who can question the credibility or criticize the findings, technically speaking, and also point the court to contradictions in the report or issues relating to its severe deviation of the facts, you have a chance of getting the court either to ignore it, as I said, or refer it back to the same expert committee and inviting the expert committee to address the challenges or the criticisms or the comments made by the parties, or even refer it to a totally different new expert, which would mean that the judge has lost faith in the expert's determination. However, the chances of that happening are not necessarily big. They happen, but it will boil down to the effectiveness and ability to persuade the judge by the lawyer, supported by someone like Rana, who knows the technical part and could poke holes at the expert determination. Something comes to mind anecdotally. I used to have, or I actually still have somewhere, a book that is uniquely entitled in a few sentences long. So the title is actually a few sentences long. Obviously, it's in Arabic, so I will just paraphrase it. I remember it quite vividly. It says, court mandates to experts in the Arab world. What was left for the judge to decide? But I think it's a very telling title.
I'm tempted to ask how long the book was. It doesn't sound like there'd be much left for the judge.
You're right, and the court goes on to criticize how it has become now more of a practice for the judge to simply defer everything to the expert.
Yes, As a follow-on to that question, if I, as a party to a case, suspect from the conduct of the expert or their draft reports that the report is going to go strongly against me, what steps can I take to protect myself or increase the chances that the court will set aside the report?
Well, there are guerrilla tactics, which I'm very willing
You
to
don't
share.
have to say all the tactics, Mohammed.
But there are also standard tactics, which would involve, again, showing how procedurally the manner in which the expert conducted himself was wrong. I think that's your best bet, because you hit it on terms of validity. So you're questioning the inherent validity or lack of the expert report. I think the second practical tip would be to have, again, as I said, a consultant with a big name like Deloitte, with vast experience, who would show the court that the proper determination is X, and how the expert's findings are too much deviated from it. Another thing which I found very useful is to try to show how the expert's findings are illogical based on the documents that he has had. Now, I appreciate that this might not necessarily work every time, but in my experience, where indeed you know that the expert will completely go off piste, there are usually documents that they are either shied away from addressing and ignored completely, which you can point to and tell the judge, well, at the very least, the expert has not comprehensively addressed the evidence. He has simply ignored some, which a lot of experts do, not necessarily with any bad faith, but as Rana mentioned in the beginning, sometimes the court mandates charges are very little. We're talking maybe of something between 10 and 15 or 20,000 dirhams. So they simply will not go through everything. So one tactic is to overwhelm them with documentation and then claim that they haven't addressed all of them. And I can tell you that they will not be addressing everything, because they simply will not have the time and will not be willing to spend the time, because they are on a very tight budget. So that's another practical tactic, which I would say it's a borderline guerrilla tactic, but I think it can fly.
It strikes me as somewhat risky. I mean, the court could take its own views on your treatment of the expert there, but under circumstances that may be the necessary approach.
I agree. Obviously, it's not risk-free.
Right. Okay. One last question before we turn over to some of the excellent questions from the audience. As you know, COVID is our new reality. It seems to be something we're going to be dealing with for the foreseeable future. How has the COVID situation impacted the court expert procedure?
Is this one for me, or?
It's an open question.
Rana, do you want to have a first stab?
No, I think go on, Mohammed, you have the experience.
I mean, possibly one of the few advantages of COVID is having more formalistic, or not formalistic, but formal expert meetings. You will recall, Nicholas, I'm sure you've attended your share of expert meetings. Usually the expert meetings are held very informally. Seldomly, in fact, does the court-appointed expert himself hold the meeting. Usually he assigns one of his associates or assistants, because he just can't afford to attend all expert meetings, which, first of all, is a handicap, because you don't have the person who will be making a finding listening to you, but rather there's a middleman. And of course, things are lost in translation, because even if the issue will be all on paper, well, what's the benefit of having a meeting? That ability to speak to someone, to persuade someone orally, was lost sometimes. Now with COVID and the formalities in place, the expert himself has to attend. Now, legally speaking, he always had to attend, but now they actually have to attend because they don't know who's actually going to be attending on the other side or who's going to be taking notes, etc. So now they're serious about formally attending. This is a first advantage, which I think cannot be undermined. The second advantage is that usually, sometimes you would realize that the expert meeting turns into a fight, literally a shouting competition between lawyers on each side, because they want to speak over each other, because they feel that their case will be furthered if they do so. But with online system of meetings, because everyone is conscious that that sort of competition will not work because no one will hear anything, even the experts. I think the party representation have become more reasonable, more professional, and more allowing for parties' position to be articulated in a proper, complete manner. And I think it's bad news for parties who used to approach this with a bit of create havoc and hopefully things will be confusing enough that you might win. That is no longer the case. So that's obviously good news as well. And I think lastly, the having online expert meetings allows also for proper representation. Many times you have an expert meeting the same day in one part of town and then another part of town, and the lead counsel cannot make himself available for both. And usually experts had very little tolerance for rescheduling meetings. So having online meetings has facilitated the ability of lead counsel to be involved in every expert meeting, as opposed to pushing it down to associates or the like. So overall, I think there is good news with COVID, and there is good news with online expert meetings.
Excellent. I completely agree. Now, I'm going to turn to some of the audience questions while we still have time. The first one relates to the potential liability of an expert. We all know that in arbitration, it's currently a live question as to the potential liability of an expert. But to what extent can a court-appointed expert be held liable in relation to their expert report?
I'm working with Rana on a number of matters, and she's very clever about ensuring that her expert report includes a lot of caveats. So if you're as clever as Rana, probably those caveats will protect you. But obviously, if you don't have those caveats, and there is a serious error, serious potentially intentional error, obviously the expert could be liable. Now, I'm talking about the law here. Practically speaking, it's going to be very difficult to find a consultant, a private expert, a consultant, or a court-appointed expert liable, or found to be liable by the courts. It's going to be, the threshold is, practically speaking, is very high. So I would think, yes, potentially pursuant to the law, but in practice, rarely or even impossible.
Excellent. Thank you very much. My next question, let's see. As a lawyer, what will be your strategy if the judge accepts the expert report at first instance, which you feel to be completely in error? Is there any prospect at the appeal stage to have the expert report overturned or for a new expert to be appointed?
Yes, I mean, that's usually the hope. So you try to do it in the same stage, but you hope that at appeal, assuming that you've made the point very clear at the court of first instance, you repeat the point before the court of appeal. You emphasize and highlight how the expert's findings are wrong, If you're clever enough to bring in a consultant on board who would support your findings on issues of technicalities, then yes, you have a good chance of getting it back to the expert or getting it to a new expert.
Absolutely. It seems like it's a common theme here that if you have any hope of challenging a court-appointed expert, you really do need to consider a party expert.
I think Rana, I don't know what your experience is, but I think that's true. Particularly if the criticism are issues of technicalities. I think that gives your criticism credibility.
Yes, independent weight.
Precisely.
Yeah, agreed.
Another technical question. Is it mandatory that the expert proceedings will be held in Arabic?
I'm afraid so. However, having said that, I've attended ones that have been in English. So if parties agree informally and the expert minutes are put in Arabic, that's fine.
Yeah, I mean, just from my experience, I can add that we, in a few cases, we had non-Arabic speakers experts from Deloitte acting on behalf of the parties, and there were a translator in the room to translate what they have. I mean, they're not testifying, but the arguments that they're using in the report and so on. So you can arrange for a translator to be in.
Fantastic. One further question. I think our panel, as the audience knows our panel well by now, they've asked for some war stories. This question says that they're curious as to our views or war stories in respect of extensive delays with court-appointed experts. Has any panel member ever had to apply to have an expert removed where the delay was excessive or unjustified?
Yeah, I mean, in many instances, Mohamed can speak about the legal element, but you can change an expert if you're not convinced with his conclusions. You can request for that as long as you show that why are you claiming that he is not reaching to the right conclusions. And the key thing here is really to critique it in a concise way and a way of that the judge can understand it. It's not like again, I'm coming to the same thing, that you don't use very technical words where the judge says they're complicating stuff too much and I'm just going to rely on this report that is in front of me. Don't make things, don't make his life difficult. You have to make his life easier. So in many instances where I've worked, assisted the clients with as a dispute advisor, we have managed to change the expert that was appointed by the court-appointed expert, and another expert was appointed to look at the matter. Mohamed, over to you probably to share your experience.
No, I completely agree, and there are potentially even penalties before formal removal that the judge can impose on an expert who's late or who's not dealing with the matter. So there are ways and means to penalize the expert, or as Rana mentioned, ultimately remove him if you want, provided you have justifications for that.
Absolutely. Now, I believe we are out of time. So I'd like to thank our panelists, Mohamed, Rana. This has been a very informative session. Thank you very much for providing your input and advice.
Thank you.
Thank you very much for attending this webinar, and feel free to reach out even after the webinar if you have any questions.
Absolutely.
Thanks.
Thank you everyone for joining the webinar. We hope you found it informative. Thanks also to Mohamed, Rana and Nicholas for their insights. If you have any further questions, feel free to email us. We are now closing the webinar. Many thanks.